All right, welcome to the maiden voyage of the Energy Bad Boys podcast. I'm your host, Isaac Orr, and I'm joined today by my co-conspirator, Mitch Rolling. Mitch, you want to say hi to the folks at home?
Hello, folks at home.
All right, that is very extensive. So just to set the table a little bit, we do not plan on making this a weekly show. Basically, what we want to do with this show is use it as an opportunity to learn about things in the energy and environment space that we are not experts in. So hopefully you can also learn something while we learn something. And today we're going to be talking about the Chevron Doctrine. Is it dead? And if it is, now what? So we have a very special guest with us today. His name is Justin Schwab, and he's the founder of CGCN Law, a law practice in DC focusing on environmental energy and administrative law. He served as the Deputy General Counsel at EPA from 2017 through 2019. And prior to that, he practiced administrative law at Baker Hostetler's DC office. He clerked in Utah, correct, Justin?
Mm-hmm. Yep, for the Utah Supreme Court, and before that for the Second Circuit Federal Court of Appeals.
Excellent. So, Justin, welcome to the show, and thanks for being our guinea pig. We really appreciate it.
Thank you very much, and we'll try to keep all of our conspiratorial status unindicted here.
Yeah.
So the big news, there are a bunch of important cases, obviously, that the Supreme Court decided this term, including multiple cases in the realm of administrative law. And when we say administrative law in this context, we're talking about executive agency regulations and rules that often have the force of law. And then if someone wants to litigate and sue in court saying, I don't like this regulation this agency issued, how the reviewing court deals with that. And so the biggest shoe that dropped is, I think, the second to last day of the term, the Supreme Court announced in a case called Loper Bright that the 40-year-old doctrine of Chevron deference has been overruled. And I can give you the soundbite of what that means, but then let's break down what that really means in practical terms, how it's going to interact with our system of administrative law, and then how much it will or won't change the rules of the road, and then what we can look for going forward. So the top-level soundbite is federal courts are no longer permitted to defer to a federal agency's interpretation of ambiguous statutory language. So that's the soundbite takeaway, but let's really unpack what that means. And I think the best way to do that is to take us back for a second to sort of schoolhouse rocks and the three branches of government and sort of the classical model that we all learned in middle school and high school history and civics class of how things are supposed to work. We have in this country, and the structure of our federal constitution embodies this, we have, or at least we once upon a time thought we had, a very strict concept of the separation of powers between these three branches of government. And the best way to illustrate it is in terms of each branch of government's relationship to the law. The legislature, the Congress of the United States, is supposed to create the law. It enacts through statutes that it passes, and then the president signs or the president vetoes, but then Congress overrides the veto. Congress writes the laws. Congress writes the laws within the framework of the federal Constitution. It can't issue a law restricting the freedom of speech, whatever that means under the First Amendment. But within the box of the Constitution, within its assigned powers, the Congress can write legislation. It makes the law. The executive branch, headed by the president, carries out the law. So, if Congress writes a law saying, hey, go build a bunch of bridges, the executive branch goes and builds the bridges. If the Congress writes a law saying such and such is a federal crime, prosecutors within the executive branch will charge people with the crime, execute the law. They carry out the law. The third branch, the judiciary, this one gets a little fuzzier. You can put multiple labels on it, but it interprets.
Yeah, thanks a lot, Marbury versus Madison.
Well, it's funny. We'll get into this, but parties, people who don't like the Supreme Court getting rid of this, I should say that people generally criticize courts of all stripes and administrations, but maybe particularly the John Roberts Court. A lot of his critics on the left will say, you're claiming to be very reserved and minimalist and not take a lot of power, John Roberts, but you're really asserting that the judiciary rules everything. Well, he's doing that in a 220-year history because that's exactly what happened in the seminal case of Marbury versus Madison 200 years ago that established judicial supremacy as we see it now. But so what does the judiciary do? It interprets the law, or it acts as a check to make sure that the executive has complied with the law that Congress wrote and sort of not exceeded, has faithfully carried it out, but has not overstepped its boundaries and has not done things that the statutes from Congress or the Constitution forbid the executive from doing. So that's sort of, the classical Montesquieu separation of powers, three-legged stool of the government view. However, reality is messy, and the execution and carrying out of the law is complex and messy. And so critics of what the Supreme Court just did and defenders of the Chevron Doctrine, which we'll get into unpacking that, say, and they're right, to some extent they're right to say this, hey, the very first Congress told the executive branch to go sort of figure stuff out and make decisions. The laws of Congress have never been a strict computer code that the executive just has to follow robotically without expanding and adding to it itself. Examples that are pointed to often as the sort of earliest examples of this are figuring out for customs purposes how you were going to treat, how the federal customs officers were going to view things physically coming into this country, whether they were going to put them in quarantine, what exactly they were going to exact from them. Congress, from the very beginning, the defenders of a deference to the executive branch say they were always given those kind of tasks to figure out and fill in the details. And that's true as far as it goes. Veterans pensions gets mentioned a lot, as from the Revolutionary War on, you have a body of veterans who have been promised certain things. How do you make sure that they're getting them fairly? You make case-by-case determinations. You evolve policies on the Veterans Board or what have you as you go on. That's all well and good, and that's certainly true up through the first couple generations of the Republic. But really starting in the late 1800s with the creation of the Interstate Commerce Commission, and then in the first decade of the 20th century with the Pure Food and Drug Act and the beginnings of what we now know as the FDA. And certainly once you get into the Wilson era, the 20s, and then, on steroids in the New Deal, you have Congress. Well, first, the executive does it on its own sometimes, but in the New Deal and afterwards into the Great Society, even now, you have Congress legislating. So Congress writes a law, and that law creates an agency within the executive branch. It says there shall be a Bureau of Widgets, and the Widget Act says there'll be a Secretary of Widgets. And generally, in broad strokes, we want the widget agency to make sure that widgets are efficient or are safe or are aesthetically pleasing or what have you.
Sure.
And then the executive agency that the Article 1 legislature has sort of created within the executive branch, Article 2, is Congress delegates and transfers and assigns some subset of Congress's own rulemaking and lawmaking authority to that executive agency. And what I just said is just an objective description of how the system, some people always worked, at least in a small level, but more and more throughout the 20th century and the growth of what we call the administrative state, this became more and more and more how things operate. So think of the creation of the Securities and Exchange Commission after the stock market and banking crises, bank and securities regulation, all of the New Deal so-called alphabet agencies into OBJ's Great Society. Congress gets more and more in the habit of creating these agencies or giving new assignments of rulemaking power to these agencies that it's already created, and then spelling out in broad strokes sometimes, we want you to go issue regulations and rules to sort of fill in the details of this sometimes very high-level scheme we're giving you. And so that's when we talk about agency regulations, that's essentially what we're talking about. So that's sort of how, and what I just described, even Justice Thomas, who's seen as sort of the most hardcore opponent of the last 100 years of evolution of the administrative state, even Justice Thomas would say, yes, that can be done if Congress gives specifically precise instructions and if the agency doesn't exceed its boundaries. You got to run a railroad. Like, we understand that there's going to be some assignment of filling in the details by Congress to the executive, and that we, the judiciary, have to respect that at some level. I would say even Justices Thomas and Gorsuch, who are seen as the hardcore ones here, acknowledge, yes, this can be done. Justice Scalia, who may have had that mantle in earlier generation, he would say, yes, the legislative power exists within the legislature, But within properly controlled and policed boundaries, the legislature can delegate some of that rulemaking authority to the executive, the same way that within some boundaries, administrative tribunals to sort of decide whether people should be punished individually for violating a rule. Some of that at least can be done on the administrative side with a limited judicial review afterwards. Everybody basically acknowledges to some extent that this is the system we have and that this is not a violation of the original constitutional intent. I say everybody, obviously some people will disagree with that wildly, but that's kind of the mainstream rules of the road, even within the extremes of the two sort of wings of the Supreme Court we have. Everybody in theory agrees on this. But when you get to Chevron deference is announced in a 1984 Supreme Court case. And that case is Chevron is the defendant, at least at the lower level, and then the Natural Resources Defense Counsel is the plaintiff. So the government is involved. I think they intervened, but strictly speaking, how this starts is the Natural Resources Defense Counsel brings a lawsuit saying that Chevron is violating the Clean Air Act and violating the Clean Air Act in the following way. The Clean Air Act creates, after its 1977 amendments, one of the core programs of Title I of the Clean Air Act is something called New Source Review, which a lot of people interested in energy are probably interested in, because New Source Review is sort of what it sounds like. The original structure of the Clean Air Act in 1970 didn't have this program. It has a very interesting history. It was actually ordered to be created by a court. We won't get into that unless you want to.
No,
but
that's all right. Yeah.
In the 1977 amendments, Congress said, okay, we're going to write this into the law. EPA under court order has been doing it through regulations, but we're going to take it and we're going to put it into the Clean Air Act itself. And what New Source Review provides is if you're creating a brand new source of air pollutants, a factory, a power plant, a steel mill, what have you, if you're either creating a brand new source or if you're doing a major modification to an already existing source of air emissions and emissions of air pollutants, then if you're significantly increasing the emissions or the potential to emit of that source, either by creating a brand new major source or by doing a major modification of an already existing source, then you may need to undergo what's called a New Source Review. And in areas where the air quality does not meet EPA standards that are issued under another program, you have to do non-attainment New Source Review, which is much more stringent. But generally speaking, under either of these programs, regular vanilla New Source Review, also called prevention of significant deterioration, or the more hardcore non-attainment New Source Review, if something is going to be a major new source or a major modification to the emissions potential of an existing source, then you need to identify potentially what is the best available control technology or BACT to control pollutants from this kind of source. Or if you're in that more hardcore non-attainment area, the lowest achievable emissions rate or layer, which is it's what it sounds like. It's, as blood from a stone. Either way, you need to do this analysis. It's very lengthy and expensive to just do the analysis and do the back and forth with EPA or with the state permitting agency where they've been delegated the authority to do that. And then you may need to install very expensive and burdensome controls. And this is not just a question of, won't you think of the profits of the company involved? There's no free lunch. That cost is going to be passed on to consumers. When it comes to the utility sector, this is going to start affecting rates. This might start to affect reliability and availability and supply of energy. So it's a big deal. So that's what New Source Review is. And the Reagan EPA announced a policy under which, when you're assessing whether a modification or this really makes more sense for a modification to an existing plant. Okay. When you're modifying an existing plant, what the Reagan EPA policy was, ironically, Justice Gorsuch's mother was the administrator of the EPA at the time in question. That's just one of these ironies of history. But when you're doing an overhaul, let's say, to a plant, the Reagan EPA policy was you can look at the various modifications being made across the whole facility, the perimeter or the fence line. They didn't use this word, but that term has come into vogue over the fights of the Clean Power Plan over the last decade. The whole fence line of the facility, which may have lots of little individually regulated stacks and plants and processing facilities and generators and what have you, you can act as if there's an imaginary giant bubble being placed around the entire campus of the facility. And you can average out and offset against each other all of the increases and decreases in the emissions or the potential to emit that all the various modifications are you making. And only if on balance, on net, when you do the pluses and the minuses and when you factor them all out across the whole plant, only if the project as a whole, all the stuff being done in reasonably contemporaneous time and blah, 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 only if the project as a whole in that overall bubble of the whole plant, only if that will lead to a major increase in emissions or potential to emit, then you need to go through the new source review, further analysis, and potentially being required to install new controls. That was the Reagan policy. It was a departure, arguably, from a prior policy in the Carter administration. The Natural Resources Defense Council said, I don't think so. They said, first of all, you haven't explained your departure from the policy, but their reading of the Clean Air Act was that you had to look source by source to each individual smokestack or thing that emits, a vent, a doohickey, a smokestack, what have you. And each of those individually, you had to do the analysis, and you couldn't net them out and subtract them out and take this bubble view. You had to go stack by stack, vent by vent, and at the most granular level of everything that was subject individually to regulation under the Act, you had to see whether that would meet the bar, that particular micro change would meet the bar of a major increase in emissions or potential to emit, and you couldn't net it out. So obviously, the reading of the Reagan EPA, on which Chevron relied factually in this case and going forward on its project, would lead to fewer projects needing to go through full new source review, because sometimes you are making a lot of changes and sometimes they average out to be minimal or even a decrease overall. The Natural Resources Defense Council reading, under that, a lot more new source review analysis and controls have to go forward because each individual source can trigger that. You're not bubbling. So that was the policy dispute. And it has a complicated, tangled history we're not going to get into in the lower courts, but by the time it gets to the Supreme Court, the way the Supreme Court treats this question is the context in which the Supreme Court announced this method for proceeding and interpreting a statute, that an agency is passing rules under the authority of that statute or adopting policies under the authority of that statute. That's where this formulation came about. And what the court did is it laid out the messy history, and the court was like, look, this statute is insanely complicated, and we got the definition of a source under Section 111, which is what the Clean Power Plan later would be issued under, and then that feeds into the whole new source review statute, which was added and bolted on later, and can't make heads or tails of this. We genuinely cannot tell what Congress's answer to this question would be. They didn't spell it out anywhere. And this question of whether you can bubble, a source is defined as any building or collection of buildings or equipment that can emit air pollutants. That is a Rorschach plot. You can read that either way to address this question of whether you can bubble or not. And so the court said, look, we can't tell, but this seems like a reasonable way to proceed under the statute. And more specifically, what they said is, when they were meta-explaining in the Chevron opinion their methodology, they said, when Congress has spoken to the precise question at issue, our job is done. If we can figure out, yes, Congress has spoken to, not necessarily literally in black quotable text on the page, Congress said you can bubble or you can't bubble, or the agency gets to decide whether it allows bubbling or not necessarily looking for that kind of literal, but sort of using the traditional tools of contextual statutory interpretation. You look at your dictionaries, you look at the structure of the statute, you try to figure out what's going on here. If you can come to a clear answer that Congress has spoken to the precise question at issue, you're done. If the agency is in line with that congressional intent, the agency wins. If the agency is contradicting that congressional intent, the agency loses. So that's became known as step one of the Chevron Doctrine. Has Congress spoken to the precise question at issue? And then over the decades, as we'll discuss, this evolved into just, is the text ambiguous? It's not quite the same thing, right? Originally, it's not 100% clear in the original enunciation in 1984 of the Chevron Doctrine. It's not clear that they meant this as a purely just kind of, we're looking at the words of the statute on the page of the law book and we're sort of linguistically and textually interpreting that. They were using it in a looser sense originally, which would include those kind of, what do these words mean, but would also kind of include like, what's the purpose of the statute? Is there a space for policy choice here? That would later split and evolve into different doctrines, but they're all fused together originally in Chevron. Step one, did Congress speak to the precise question at issue? If so, we're done. But if not, you proceed to step 2. And then the court should not be asking itself, what do I, Mr. Smart Fancy Pants judge, think is the right answer here? But instead, you're looking at the interpretation of the statute that the agency is putting forward, and you're saying, is that a reasonable approach here? On the evolution of the linguistic track, is that within the range of reasonable solutions to the ambiguous riddle of the text that Congress has given us? On the policy understanding, which sort of fell away and became a separate doctrine, which Chevron doesn't touch, and we'll get into that later, you can view it as Congress has carved out a box that the agency has to stay inside, but within that box, the agency has a policy choice of which way it wants to go, and we have to defer to that. So those are the two in the original Chevron, whether it's truly linguistic or whether it's looking at policy choices, they weren't really fleshing that out yet because the linguistic turn to textualism hadn't really caught fire in the judiciary yet in 1984. It was kind of bubbling, but it hadn't really become today, all 9 justices from Kagan to Thomas, they will all, or, Jackson and Thomas will all say, we must start with the text. Well, in 1984, that wasn't so clear, right? It was also what's the purpose of the statute, et cetera. So to recap, as the Chevron Doctrine evolved, it's a 2-step analysis. Step 1, is the text of the statute that Congress wrote unambiguous on the question at issue in the case, the lawsuit before us? Here it's the Natural Resources Defense Council is suing, saying that this bubbling policy is not allowed under the Clean Air Act. Are they right? Or is Chevron and EPA, are they right that it is allowed? Can we tell clearly one way or the other? No, we can't. This is a mess. This is a very complicated statute. We can't tell whether Congress, Congress didn't spell this out, and we can't tell. If you sat Mrs. Congress down and asked her, what did you intend here? Mrs. Congress would say, well, as far as we can tell, right? So in that case, you proceed to step 2. Is the agency's reading of the statute a permissible one? This is phrased as, is it rational? Is it permissible? Is it within the bounds or range of reasonable resolutions of the ambiguity? Slightly different formulas, but you kind of see what they're getting at. Then the agency wins. And the snake is in the garden here already. The fly is in the ointment here already, where you can see what this arguably already is in Chevron, what this is going to lead to, and then what the Supreme Court 2 weeks ago just said, is that this can lead to the scenario where the statute's ambiguous, so there are multiple theoretically plausible ways to read it. The court might say, the judge or the panel of judges in a circuit court might say, I'm reading it as X. I think that's the best reading. Can't be 100% sure because it's ambiguous, but X makes the most sense to me of this is what Congress intended here. And the agency is saying Y, and Y is contradictory, or not X. It's saying some other thing, which is mutually exclusive with my reading. But even though I think that my reading as the judge is the better one, as long as the statute's ambiguous and the agency's reading is plausible, it crosses some bar of reasonability, rationality that, yeah, Congress might have meant that, then the agency wins. You have to defer to the agency. And that's why it's called Chevron deference. And so to hear the Supreme Court majority from 2 weeks ago, that is an anomaly with the law, and it is not permissible under our system. And then I'll explain what I mean by that in a second. But so let's look at the evolution of how Chevron deference evolved in the 4 decades between 1984, when the case first came out, and 2024, when it was overruled just now. First of all, it's far, it is not clear that the Supreme Court thought in the Chevron case that it was doing something revolutionary. You get a flavor in the opinion, which I believe Justice John Paul Stevens wrote in the opinion there, that he's kind of just, this is how it works. Like, everybody kind of knows that when you're grappling with an agency rule and a murky congressional statute authorizing some kind of rule, that, you got to kind of defer to the agency because they're the experts here. Some sense of that was in the air. There have been empirical studies trying to demonstrate before the Chevron case how many courts were already doing that. That seems to be the most common way over the decades and generations prior to 1984, in which federal courts were dealing with federal agency interpretations. They were deferring them pretty often, but not all the time, and not in a thought out systematic way. So colleagues of mine who were in law school when Chevron came out, they were sort of admin law nerds 40 years ago. I've asked senior colleagues of mine, did you realize this was a revolutionary thing? And they said, not really. Our professors noted and was like, yeah, this is interesting, but, this just kind of confirms what we thought. It's a nice little hook to peg on it. However, over the intervening decades, Chevron came more and more to the forefront of how we talk about and think about administrative law, where it is one of the most cited Supreme Court opinions ever. Certainly the most, at least given its age. I mean, there are some older ones that might get cited more because they were issued in the 1940s, but for something that's only 40 years old, it's probably been cited 40,000 times, would be my surprise. It's just whenever you're dealing with an agency telling you what its rulemaking statute means, you tend to cite that. Okay, so it's been cited thousands, tens of thousands of times. Not necessarily in this unique scenario where at step 2 the agency wins, even though the court says, I think my reading is better, but you still win. That's relatively rare. But the background framework of that 2-step deferring where there's ambiguity, that seeped more and more to the groundwater where this became very, very foregrounded. That's thing one. Thing two to note is that more recently, Chevron Doctrine and Chevron deference has been identified by people who are opponents to what they see as agency overreach and the administrative state's expansion and aggression. It has been identified by the critics of the administrative state as one of the main enabling tools of agency overreach over the last 40 years. But that is certainly not how it started. Again, the policy at issue in the Chevron case of allowing bubbling, allowing an averaging out of all emissions changes, and then saying we're only going to look at the sum of those changes to determine whether you need to go through the full third-degree new source review, that is, one would argue, a deregulatory interpretation or a flexible, light touch, pragmatic, whatever you want to call it. Remember, it was the Reagan EPA coming in and saying this. Prior to the previous administration's EPA, the Reagan EPA was seen as trying to bend. The EPA was headed the most in history. And the Natural Resources Defense Council, right, was the ones who challenged it. And Chevron and the Reagan administration's position won the day. So in theory, the Chevron Doctrine cuts both ways. And in theory, the Chevron Doctrine defers to a more, let's say, muscular administration's interpretation of its authority, its more aggressive interpretation of its authority. You should defer to that as long as there's ambiguity and your interpretation is reasonable, just as you would defer, as in the Chevron case itself, to a less burdensome, let's say, for the regulated party policy and interpretation. So the third reason would be Justice Antonin Scalia. Justice Scalia, I believe, was on the D.C. Circuit when Chevron came out, and then he was elevated, I want to say, a year or two later. But he sort of became the biggest champion of the doctrine of Chevron deference. And he sort of took a sort of personal possession of it almost, where he was, spreading, if it's blasphemous, spreading the good news of the Chevron deference, right?
Sure.
Far and wide, and saying, look at what, hey, if if you understand how you do this, like, this is actually the right way to do it. And this is a good segue to do a brief look at what are the justifications, the sort of theoretical meta justifications for Chevron deference. There are two originally in the immediate aftermath of Chevron, but then one of them kind of falls away. One of the justifications is the agencies are the experts here. By definition, you don't get into Chevron unless you have a regulatory statute where Congress has said, okay, widget agency, you go and regulate widgets. And then it's ambiguous, meaning a court with all of its learned power can't 100% be certain what it is Congress intended. So by definition, you're acting in an area where, like, the agency's expertise, maybe you think that the right thing to do is to defer to the experts who have a PhD or whatever and spend all day, every day doing this. You're a judge who was an English major in college. The last time you took a math or science class was in high school. A lot of the time, just leave it up to the experts. And you see evidence for this. I forget which justice. It might have been Justice Blackmun. His papers from his personal papers were released, or at least a journalist saw them. And he had notes in the margin of his conference agenda or whatever, saying something like, when I don't understand, then the agency wins. And this is kind of, I'm not trying to slander late Justice.
Sure.
Justice Blackmun, but that's kind of the flavor of I just work here. This is going way above my head. You seem like your heart's in the right place, agency, so you win, right? That's kind of one of the flavors of defer to the experts. Scalia doesn't like that, right? Because that aggrandizes sort of the power and authority and prestige of the civil service and the agencies over the rest of the system. Scalia picks up on the other justification, which is already to some extent present in the Chevron case, but which becomes more and more the defenders. And you see this all over the dissent that was just written in the Supreme Court saying, no, we shouldn't get rid of Chevron deference. And that's a more political science justification. To go back to the separation of powers we were talking about earlier, there what they're saying is, look, Agencies are more democratically responsive. They're appointed by and subject to the will of a president who's elected every 4 years. But judges are there for life. Once a judge gets confirmed, it's essentially impossible to remove them. I think there have been 12 attempts and 6 successes to impeach federal judges in the history of the republic, whereas, presidents lose elections all the time. So the theory here is you'd want the people who are more responsive to popular will, and we can argue about whether that's actually empirically true of the bureaucracy, but this is the justification. You want them to be making the call where things are murky. And so we, Justice Scalia is saying, we, the court, have put Congress on notice that we are assuming that when it writes an ambiguous statute, unless it specifies otherwise, it wants us to defer to the federal agency's reasonable interpretation of that as kind of we're respecting implicit congressional will ultimately, and then we're deferring to the heightened democratic responsiveness of both the legislature and the executive. And hey, we judges, we just work here. We have this quasi-king-like role, priest-like role anyway, because it's very hard to get rid of us. We serve for life. We don't have to do, at least at the federal level, we never need to elected on the front end or the back end. Very different from how most states works, but that's how the feds work. That was the justification that took on more and more and more emphasis. And the linguistic turn was happening where first the right wing of the judiciary, but then eventually almost everybody started saying, and we really need to start in all instances with the text of what the statute that Congress wrote and really focus on that. And yeah, you can look out to the histories in conference and your common sense and all of that to kind of confirm that, but you really need to start with the text of the statute. And if this seems very obvious to us, of like, yeah, how else would a court do it? Go read some Supreme Court opinions from the 70s. And they'll say like, we know what Congress's purpose here was. It enacted the Widget Act to have good widgets, and here's the agency policy, and that makes a lot of sense. Oh, and if you look at the text of the statute, this confirms that the agency's right. So in other words, a lot of justices, this wasn't a left or right thing. It's called purposivism, which is what is Congress's purpose here versus do you start with the text? That slow-moving revolution to the text-centered, start with the text and then work your way up and out from there, that caught on. It was probably a right-wing thing originally, but as I said, Kagan and everybody else, Kagan got a dictionary too. And Justice Elena Kagan is very, very, very good at interpreting text, right? So, kind of more progressively minded justices and their advocates and their political backers and the people who nominate and confirm them started saying, hey, we can play this game too. Who says these statutes only cut the way that the right-wingers want, or the way that the red states want, or the way that regulated industry wants, And so all of that confluence meant that Chevron deference evolved to really be squarely focused on the linguistic and textual legal interpretation of the statutory text. It became more and more wrapped up in this separation of powers and democratic justification for, we're just little life-tenured judges. We shouldn't be, aggrandizing our role here. And at least in I would say, the 80s and the 90s, and to some extent in the aughts, Justice Scalia and a lot of other, fairly hardcore conservative judges said, we like this thing, we're comfortable with it, shouldn't be scared of it. So that's sort of the evolution. Now, I noted that it cuts both ways, that Chevron deference, at least in theory, is going to go for regulatory and deregulatory interpretations of the statute. So why has there been such an association in more recent years and decades of Chevron deference with an enabling of the expansion of the regulatory state? I would argue that that is real, and on balance, if someone who opposes more aggressive regulation should support the overruling of Chevron deference, and we'll get to why they overruled it in a second. But why would this be a little bit of maybe an optical illusion? I would argue it's this. Okay, Congress legislates less and less often with every new 2-year Congress, every new presidential term, every new decade. This is just empirically pretty obvious. The Clean Air Act itself tells the tale. Created in its modern form with binding teeth in 1970, significant overhauls in 1977, massive overhauls and expansion in 1990, and then for the next 34 years, there has not been another massive overhaul. Renewable fuels statute, the ethanol stuff, and all that biofuels was created and bolted onto it. The AIM Act, which had the phase down of hydrofluorocarbons, that was added and bolted onto it recently. But the overall thing hasn't been overhauled. And that is an example similar to a lot of other subject areas, not just environment and energy. And so if you are, let's say, a more active or progressive presidential administration, or if you're a permanent civil service, who either way, you identify a problem out in the world, and Congress is not, from your view, responding to the problem. President Obama, remember, President Obama famously said in as many words, I want Congress to act. That's how it should work in our system. But if Congress doesn't act, I'm not going to stand idly by. I have a pen and a phone. I can sign presidential memoranda and executive orders, and I can call up my cabinet and say, hey, let's get creative with our regulations here. Right? That's the dynamic. So over time, the wing of things that wants to do more regulating, if there are fewer and fewer new legislation being passed to say, okay, widget agency, you got a whole new bag of tricks now. Well, then the widget agency is going to have to get more and more creative with its reading of how the original statute, which may be decades old by this point, can be used for these new purposes. So the evolution over the 40 years is definitely in the direction of some big ticket items, especially being argued for and winning sometimes on Chevron deference, but it cuts both ways in its origin. To some extent, without naming any names, I'll tell you, there are a lot of industry parties out there that say, hey, a lot of our wins in court when we were supporting, let's say, frankly, the Trump administration or the Bush administration most of the times, but sometimes the Obama administration, a lot of times when there was a policy that we thought was reasonable and we could live with, the agency was winning on Chevron deference, and we were right there helping them sometimes on their side of the V in the lawsuit. So, this does cut both ways to some extent. So that gets us up to 2024. Would it be helpful now to talk? I'm not going to go into too much detail of the facts of the case that led to Loper Bright, but just to orient people on what SCOTUS just actually did 2 weeks ago when it overruled Chevron.
Yeah. I think that, we can basically what I think we could talk about now is during this Loper Bright Enterprises versus Raimondo case, did they fully repeal the Chevron Doctrine?
Yes.
Okay,
yes.
They fully repealed it.
Yes.
And, I'm not a lawyer. I don't play one on TV. I know that the major questions doctrine also plays into this as it pertains to how these changes are going to affect regulations and the ability of agencies to promulgate them moving forward. So, let's talk a little bit about the Loper case. I don't think we need to get too into the weeds with it. But my understanding is that the agencies were using Chevron deference to enact a whole bunch of things that were pretty crazy. And wasn't one of the worst offenses the eviction moratorium during COVID? Were they trying to claim Chevron deference for that? Because as a landlord, that offended me personally.
There's a lot there, but yes, that's a very logical path. So what I'll do is I'll talk a little about the Loper Bright case itself and what it held, and then that'll be a good window because part of the analysis gets into exactly what you're saying, which is major questions and these other odd doctrines that are floating around it. So that was relevant to the analysis of why they should overrule Chevron, and so we'll get there. So look, on whatever it was two Fridays ago. I forget the date. So it was
it's June 28th.
June 28th, one of the multiple opinions issued that day was an opinion deciding two cases that were argued back in, I want to say, the end of January. Loper Bright, L-O-P-E-R, second word bright, like a light bulb. Loper Bright is a commercial fishing company. And the defendant there, and then the other case, the companion case, is called Relentless Incorporated. I think everybody's a little disappointed that Relentless didn't end up being the lead case just because, the Relentless Doctrine or, the Relentless Overruling, would be, but whatever. Loper Bright, perfectly fine name. It's memorable in its own right. It's just not as dramatic as Relentless. Both of these cases, Loper Bright, I believe, came out of the D.C. Circuit and then dealing with a very similar, the same basic issue. Relentless came out of the First Circuit. They were argued on the same day. They were decided in the same opinion. They weren't technically consolidated, but only the lawyers care about that. Here's what they dealt with. The defendant in one of them was the Department of Commerce, and the other one was Secretary Raimondo, who's the head of the Department of Commerce. And they were dealing specifically with an entity called NMFS, which is the National Marine Fisheries Service. Kind of does what it sounds like. It administers the Endangered Species Act for ocean species, let's say. Salmon get contentious as to which side of the line they fall on versus the Fish and Wildlife. And it administers the allowances for how much you're allowed to fish in various fisheries. That part is pursuant to implementing the Magnuson-Stevens Fisheries Act, which is a venerable act. So it goes the Department of Commerce, NOAA, the National Oceanographic and Aeronautic Administration, I believe.
Atmospheric, I think, yeah.
Atmospheric Administration, I apologize. And the NIMS.
That's all right.
And the NIMS is the grandchild that is administering and issuing the rules in question. And the rule in question here imposed on the fishing companies that are regulated under NIMS's regime, it imposed the cost, who had to pay for, the only way to call them is government minders, people who were either government employees or third-party trained people who would ride along on the fishing boats and sort of, check on the health of the fishery, but also not so implicitly make sure that the company was abiding by the statute and the regulations NIMS passed under the statute. Because, hey, you're out there on the ocean, who knows what you're doing out there in terms of what you're catching and throwing back. So you need someone there to look over your shoulder and make sure you're abiding by the statute, but also all those rules that NIMS passes that has the force and effect of law. The question is who has to pay for those? And the rule at issue said the company's got to pay for those. Now, some other parts of the underlying congressional statute do talk about making the company pay in sort of limited subject areas, pilot programs, certain areas, But the broader act doesn't say anything generally one way or the other about whether you can make people pay more generally for the minders. And so NIMS's position was, hey, this act told us go implement this policy of making sure that the fisheries are conserved and that we don't have a tragedy of the commons here, that we're not unrestricted open fishing on the open seas. The worry was we're going to get rid of all the fish. So that's the broad policy. And they told us to go make it work. And so it's the broad kind of mandate for us to go, the agency, to go make it work. That's our authority for saying, passing a rule that everybody or a much broader universe of fishing companies have to pay for the minders. So these two companies sued and they worked their way up the courts. And then both the First Circuit and the DC Circuit, in slightly different reasoning, said there's some degree of ambiguity here. And to the extent that the statute is ambiguous and we can't really clearly tell whether Congress intended that the companies pay for it, intended that the companies not pay for it, or gave that choice to the agency, we don't really know. Congress didn't have a precise intent here in the statute, but the agency's rule is a reasonable resolution of that ambiguity. It is permissible for the agency to read the statute to allow it to impose the cost on the companies. So those are the facts of the case. That's the background of the case. The majority recites those facts in explaining how we got here, but then doesn't basically do any analysis or application of it. Doesn't talk about the statute at all or the scenario with the red rules and the fishers at all anymore. Why? Because when the Supreme Court decided to hear the case, it granted certiorari or cert, meaning there was an appeal saying, please take this Supreme Court, because the Supreme Court doesn't have to hear every case that people come to it. They grant these golden tickets, 70 or 80 a year these years of I'm granting cert, I'm going to hear the case. And here's the question presented. The question wasn't, are they reading the act right? The question was, should we overrule the doctrine of Chevron deference? And there was a lesser included question of, or in the alternative, should the court clarify the Chevron doctrine to say that if a controversial power, whatever that means, is granted in some site-specific aspects of a statute, does that prevent the agency from claiming that same authority in a broader way, from the general grant of authority under the statute? They didn't need to go there. But if you think about the Clean Power Plan, arguably that clarification of Chevron could have dealt with the Clean Power Plan on its own, because the Clean Power Plan was an attempt to use cap and trade, tradable permits for pollutant emission as a way of regulating individual power plants. Well, right next door to the section of the Clean Air Act that was used in the Clean Power Plan, when you talk about the so-called NAAQS program of ozone standards for the ambient air and stuff like that, there the statute explicitly says, hey, if states and feds want to go do cap and trade auctions for the right to pollute, knock yourself out, that's a valid tool. The section that was actually at issue here of a source performance, individual source performance, doesn't say anything about that. So right there, that might have dealt with it. But the Supreme Court didn't go there. Instead, the Supreme Court majority takes the bait, no pun intended here, on that first question, and it says, we are overruling Chevron deference. It's very, very clear. They say we are not, federal agencies may no longer let the agency win where there's an ambiguous statutory text just because the agency's reading of that text is permissible. You have to actually be convinced that that's the right reading. So that is what they did. That is unambiguous, but we'll get into some of the ambiguity later. So the structure of the opinion is they go through the history of the whole administrative state, and they note that, hey, it's the court's rule to interpret the law, but as we started out by talking about over the generations, Congress started giving more and more tasks to administrative agencies, and that's fine. And fine up to a certain point. And in 1946, no coincidence, this is right after the New Deal and right after World War II and right after the second Roosevelt administration, the Congress passed the Administrative Procedure Act, which governs generally how agencies do regulations. This is where we get the famous notice and comment. In most cases, if an agency is going to issue a rule that binds with the force of law, it has to propose what it's going to do to the public, take their comments and concerns, and then when it finalizes the regulation and say, okay, the regulation is now binding, it has to respond to their comments. But another aspect, and I'm going to get the exact quote here, is that when someone sues and challenges a regulated company or an individual human being or whatever, says, I don't like this regulation that the agency's issued. I think it's irrational, or I think it's illegal because Congress didn't give them this authority to do this, or both. Then what Congress said in the Administrative Procedure Act is, quote, the reviewing court shall decide all relevant questions of law. And that is the hook on which the Supreme Court majority, written by Chief Justice Roberts, joined by all 5 other Republican appointed justices, so party line in that sense, says the text of the Administrative Procedure Act, which says that courts shall review all questions of law, Chevron deference is not compatible with that. Because remember, at that step 2, you can end up with this weird situation under Chevron deference where the court says the statute's ambiguous, so we go on to step 2, and here's the way that I, Judge Schmo, read this text. I think this is the best reading of the text, but the agency's reading is not as good as mine, but it's permissible, and so they win. The majority says you are not deciding that question of law, then you're deferring and allowing the executive agency to do it, and you can't do that. Now, notably, Justice Thomas writes a solo concurrence to suggest that it's not just the text of the congressional statute, the Administrative Procedure Act, that requires this result, but it's also the structure of the Constitution and the separation of powers itself. So at least implicitly, Justice Thomas, we think, is saying that Congress can't just go change the text of the Administrative Procedure Act and tell courts to defer again. There's some limit because Article 3 of the Constitution puts the judicial power in the court, but the rest of the majority didn't feel the need to go there. So, interesting development if Congress decides it wants to restore Chevron deference. At least one justice seems to be saying, I don't think you can do that. We just don't know for the other 5 justices in the majority what they would think about that. So,
real quick on that, can I ask something about the reasonableness criteria?
Mhm.
It seems to me you're saying that, before it was like the courts had to assess this like whole, various reasonable interpretations of a law, by the regulatory bodies. And if they hit one of those reasonable criterias, then it's permissible. What was that criteria based on? And how often did these courts say, no, this is unreasonable? Like, how flexible was that criteria?
That's an excellent question. So what you're saying would be a very logical, reasonable way to proceed under the doctrine, in which step 1, does this text only have one clear answer? If no, step 2, what is the range of possible options, A, B, C, D, E, or what's the maximum, what's the minimum, whatever. And then is the agency's reading within that? That would be the most showing your homework, the most laborious, and frankly, the most calling on the court to be completely, fully transparent on what was going on. Well, that is not how most courts and judges were doing. You get to see sort of drive-by opinions. And the First Circuit in Relentless arguably did this, where they said, here's the statute, here's the thing. We're not really sure if this is ambiguous. If it's unambiguous in the agency's favor. And if it's ambiguous, then the agency's reading is a reasonable resolution of that. And so either way, you win.
Oh, wow.
So right. Or just leaping ahead to step 2 sometimes and saying, I'm just going to assume for the sake of argument this is ambiguous, but your resolution is to, So when I say sometimes that people could play Chevron like an accordion, that's what I mean, right? And so, and then the second part of your question, which is how often were courts saying at step 2 you lose? Pretty rarely. And for decades, really not at all, at least not at the appellate and Supreme Court level. There's a famous Clean Air Act case, we won't get into the details here, but it's called American Trucking Association versus Whitman. And this came out in 2000, 2001. And what this case is always remembered for is it says that when EPA is setting those national ambient air quality standards, the NAAQS standards for what's the safe concentration of ozone or particulate matter within a given area, the agency cannot consider cost. That's sort of what everybody focuses on as the takeaway, that when EPA is setting what that safe limit is, it's only supposed to do that looking at the health science, and it can't consider the economic implications of setting too stringent a standard at all. Scalia wrote that. But another part of it is another very complicated esoteric. We don't need to get into it unless you want to, but there was another aspect under which the court there said, what Congress did here is ambiguous, but EPA, what you did by just totally ignoring one of the 2 overlapping and conflicting sets of instructions that the court gave you, you can't do that. That is an unreasonable resolution of that ambiguity. And so some of the OGs have told me that prior to that case, a lot of people thought you can't lose, the government can't lose on step 2. The House always wins once you enter the realm of ambiguity. Well, at least, that was one of the first major, maybe the first major instance of the government actually losing on step 2, not on the question of whether you consider cost, but just implementing ozone reduction schedules. We don't need to get into it unless you want to. So this is a related question of how many times were agencies clearly winning at step 2, meaning that the court was making it clear that the only reason the agency's winning is because of the Chevron doctrine. Well, the parties in the case could only identify, I think, 7 times that the Supreme Court itself had done that. And then people threw around, maybe it's 70 for the circuit courts, the intermediate level of reviewing what lower courts have done. Or a lot of the times the statute says the widget agency's regulations can only be challenged in the first instance before a panel of 3 judges in the circuit court, not 1 judge in district court in a quasi-trial context and then going up. Whatever it is, Supreme Court, 7 times people could identify where they were giving Chevron deference to the agency clearly. Circuit courts, maybe 70, hundreds, thousands maybe at the district court level over the decades. So it was a lot. But again, it's kind of hard to tell because it's pretty rare that the court would actually say, here's my reading of the statute, and I think it's the best reading, but the agency's reading is permissible, so the agency wins. If I can give an analogy, the best way to get your head around this is to think about rolling a die. You think of Dungeons and Dragons or any game, any board game in which you roll a die, okay, craps or whatever. What Chevron deference basically says is one reading of the statute is rolling against the other reading. And all the government has to do is hit a 10. If you're above a 10, you win. So if I roll a 15 and you roll an 11, I'm the regulated party that thinks the agency is reading the statute wrong, or I'm the judge who's considering whether I agree with this agency's reading. Agency's rolling their dice. As long as they clear that threshold of permissibility, even if mine is better, you still win. So that's what the court said can't do it. So just to note real briefly about some of the implications. So the court first explains, here's why Chevron, in Loper Bright opinion, the court says, here's why Chevron's wrong. And it's resting it almost entirely on the text of the Administrative Procedure Act, where Congress said the court, when it's hearing a plaintiff's challenge to an agency regulation, the court shall resolve all issues of law. And they say Chevron deference, whatever it is, it's abdicating that role. It's preventing, in a sense, the lower courts from doing their job under the Administrative Procedure Act, and so you can't do it. So they say, okay, that's why it's wrong. But then they have to go into analysis, and this is where we start bringing in major questions and stuff like that. Then the court majority goes into analysis of, okay, so it's wrong. Does that mean we overrule it? And that's where they get into the analysis of what's called stare decisis. And I apologize for the law Latin. Stare decisis is a Latin phrase that means to stand on, or maybe more idiomatically, to stick with, to stand by the things that have been decided. Stare decisis. And so the idea here is typically in our system, if a court has decided an issue of law in an earlier case, you stick with that. You don't overrule that in most cases, even if you think it's wrong as the same judge later on or a later generation of judges. That's what precedent is. That's what case law is. It's stare decisis doctrine says in most cases, you stick with it even if you think it's wrong. And you have to do a multi-factor analysis, which is a little squishy, and it's not clear how many of these factors you need and whatever. But if you get a critical mass, only if you get a critical mass of other sort of red flags with the precedent, do you then say, notwithstanding the doctrine of stare decisis, we overrule it. And in an area of great social controversy, this is what happened with Roe versus Wade 2 years ago, where they said Roe versus Wade is not protected by stare decisis, and the court majority overruled the holding of Roe versus Wade. You have a similar thing going on here in the hopefully less controversial area, although still controversial area of administrative law of this just happened with Chevron, what happened to Roe 2 years ago. And what you do in the stare decisis analysis, if you say it was wrong from day one, it was egregiously wrong, it has caused distorting effects to our whole system of law. It has not been predictable or reliable. It has not given meaningful, useful guidance to the lower courts as to how they're supposed to do their job. It has not been a stable doctrine. It has led to mutations and limitations and weird flying buttresses getting built on the outside of the castle to keep the whole system going. And they say, the majority says, that is the case here with Chevron and its progeny in later case law. And so and by definition, if it's shifting and mutating, the world cannot have reasonably reached a stable reliance on it. So for all these reasons, it's crossed the stare decisis threshold. We're not starrying on the decisis. It's got to go. Now, the dissent obviously says the opposite and says, no, it works fine, and this is predictable, and you're going to cause chaos by getting rid of it, right? That's the fight. In the context of that stare decisis analysis is when the majority says, okay, this has not been a stable doctrine. It's constantly mutating. Why? We have had to constantly spell out limitations and codicils and exceptions to it. Now, they don't necessarily get into all of these, but I'll just briefly describe it. Originally, and in early years, Chevron was used in kind of a sloppy way where any time an agency was in court talking about what its statute meant, a lot of courts would hit the deference button. And so that got in, and over time, courts said, whoa, 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 we're not doing that all the time. We're going to limit it almost entirely to in the context of a notice and comment rulemaking. If the agency adopts its interpretation of the statute in the context of proposing a binding regulation with underlying legal rationale to the public, taking their comments, responding to it in this transparent public process, at least in theory, that's a requisite. Sometimes you'll see courts saying, was this signed off at a high enough level of the agency? Is this just some random schmo, or is this the secretary or the general counsel or whatever? You want to see some indicia that this, sometimes is this really in your wheelhouse? In some exceptions, like think of the Affordable Care Act, which is being jointly implemented by the IRS and HHS. In a very prominent case there, King versus Burwell, earlier, Justice Roberts said, we're not giving you deference. You win, government. This is what commenters liken to Marbury, or I'm liking this to Marbury versus Madison. You win, but it's only because we say you win. It's not because we're deferring to you, right? So major questions doctrine was precisely one of these exceptions to Chevron. It's a little weird because the major questions doctrine was formally announced in West Virginia versus EPA 2 years ago. That was where the Supreme Court held that the Clean Power Plan was ultra vires, beyond your authority, which is a fancy Latin way for saying illegal, because the form of the Clean Air Act was built around trying to set in the Supreme Court says that the Clean Power Plan, the Obama EPA's Clean Power Plan, started with the premise of how much of the fuel mix for the utility sector do we want to be coming from coal versus gas versus renewables. And then it about calculated the specific source limits, set them so low that they could never be met without carbon capture, which at least back then EPA thought was not ready for prime time because it was too expensive and not technically feasible. But then the way you complied with these very low standards as a coal or gas plant was by buying credits from wind and solar, either because you built your own wind and solar or because you bought credits from your competitor, utility company. They said you can't do that. Okay. But why did the Supreme Court in West Virginia say you can't do that? They didn't get into deference ambiguity. There they said, we've hinted at this in prior precedents. Now we're straight up saying it. There's such a thing as the major questions doctrine. This is 2022 West Virginia versus EPA. And they said some agency actions are such a big deal. They raise such a major question of law and policy that in those instances, once we've identified a major question being treated by a regulation, in the case of the Clean Power Plan, it was, should generation shifting be a federal policy to sort of set and adjust the right fuel mix in the aggregate of our utility sector? They said that's a major question. And so in order for us, the courts, to affirm, to sign off on, to allow an agency action that does that, when we go look at the statute, we are not looking for any ambiguities or silences or gaps. We are looking for a clear statement of congressional intent to authorize this type of action. It's not enough to go on a best system of emission reduction, which is what was at issue there. Maybe not enough to go on, make sure the widgets are safe. You need a specific authorization in those major questions. Now, Chevron never came into that discussion. I think the word Chevron appears in a footnote in West Virginia because it's citing a law review article that has the word Chevron or something like that, right? But it's just not at issue. Why? When the Trump EPA repealed the Clean Power Plan through administrative action in 2019, the Trump EPA said, we have decided, using the traditional tools of statutory interpretation, that the Clean Air Act unambiguously does not allow a cap and trade scheme to be the basis of a source performance standard. And so we're done. We can't do it. We have to repeal it because it wasn't allowed. Could have been the greatest thing since sliced bread. It's not allowed. And so that was the basis and the posture on which First, the D.C. Circuit said, you're wrong, in a case called American Lung, issued the day before President Biden was inaugurated. The D.C. Circuit said, you're wrong, EPA. The statute does not unambiguously prevent you from a cap and trade scheme under Section 111 of the Clean Air Act. And because you didn't identify any ambiguity in the statute and you're not arguing for any deference here under Chevron, we're not going to give you any. And then when the Supreme Court took the case up, the major question, the EPA in 2019 mentioned the major questions doctrine, which was an emerging nascent concept at that point. It had never been squarely held by the Supreme Court, and said the agency in 2019 repealing the Clean Power Plan said, we think we're right even on vanilla statutory interpretation, but if we look to this murky emerging thing called the major questions doctrine, that confirms that we're right. That's what the Supreme Court seized on. It didn't play the ambiguity game. It didn't do that. It said generation shifting raises major questions of law and policy, whatever that means. And so we go to the act and we look for the act, not for ambiguity, but for a clear indication of intent to authorize this kind of rule. And we don't see it, so you can't do it. Okay. So question, and so the stare decisis analysis in the Loper Bright case notices this and a bunch of other weird fireworks and sort of, mutations or limitations to the doctrine, and says that's why this is not, Chevron's not a stable, workable doctrine. Query whether, as lawyers like to say, the question now arises, what's left of the Chevron, what's left, if anything, of the major questions doctrine? A lot of people, frankly, including myself, read West Virginia and read major questions as creating a sort of exception to Chevron. Under that reading of it, you don't need it at all now, but I'm not sure that's right. Because under the new, and we'll get to what we're left with after they overrule the Chevron doctrine. But
yeah, that'd be great.
We will. But what I'm saying is just that even in that regime, the court still has to figure out what the statute means. And it still might, we'll have to see how this plays out in later litigation challenging other rules. Maybe that major questions lens still provides something important to the court if it identifies an agency action as raising major questions. When it goes and looks at the statute, it's not deferring to the agency, but for the court's own job of figuring out what the statute means, the court may still need to know, am I looking, well, that's a major question raised by this rule, you better have a clear interpretation of intent, or am I, the court, interpreting ambiguity and silence and gaps, not deferring to the agency? It still may have a role. We're going to have to see how this is briefed and played out. Now we're back to the end of, the court says, Chevron, here's the history of Chevron deference. It is incompatible with the text of the APA. Justice Thomas's concurrence says it's also incompatible with the Constitution itself. Stare decisis.
God, he's so based.
He's hardcore. That man is built different. And then
well, and it's also interesting that it started as a like the Chevron. It started as a means of, people wanting to put control more in a democratically elected so-called branch of government. Even though it was the agencies, but it was almost used as a way of getting rid of any checks and balances on the agency itself.
I think that's certainly a lot of people's take on it. I'm very sympathetic to that take. There's another side to this, which is Congress, it is easier to issue a regulation than it is to enact a law and get it signed by the president.
Right.
And so, if you want a government that is sort of nimble and responds in a robust way to evolving challenges out in the world that need regulatory attention, market failure, hazard safety, what have you, that you can't do it all by legislation. This is the view. You need a responsive agency. And if Congress is not going to issue a lot of new laws, then you're going to need to accept some, let's say, stretching of the original authority given, as long as it's permissible resolution of an ambiguity. I'm not, I think on balance, it's a good thing that the Chevron doctrine was overruled, to me personally, but, there are two sides to this story. But on the democratic question, there's an interesting point, which is, it's certainly true that once they're confirmed, it's almost impossible to get rid of a federal judge. Whereas every 4 or 8 years, you have an election for president. Every 4 years, you have an election for president. 2-term limit means that only once since the Second World War has a party stayed in power for 3 presidential terms, H.W. Bush succeeding Reagan. And so you're going to have more turnover at the political levels of the executive. Fine, that's true. And that the secretary, general counsel, whatever, those are all appointed, nominated by the president, who was elected by the people, and then confirmed by the Senate, who were elected by the people. Okay. But it's not a complete night and day difference of 2 reasons. One, The judges are nominated by the president, who was elected by the people, and then are confirmed by the Senate, who were elected by the people. Now, you can say, yeah, but there's no way to get rid of them after the fact. Well, one is, it's not all that easy to get rid of the permanent civil service of an agency. I mean, you Schedule F and all those fights over it, but, it's kind of hard. Two, I think a lot of people feel if they want a significant policy change, there's a lot of thought it's not a dime's worth of difference between the parties, or, hey, we elect someone who says they're going to change things, but then it's very hard to turn the battleship around. You have this inertia. You have judicial review of any change in policy, or most changes in policy. And so, it's a lot harder to steer that ship. And you think, I'm just suggesting that the difference in terms of democratic response to this is not as clear cut as some people want to say it is, although the life tenure protection for a federal judge does mean something. So let's go now to just say, okay, what are we left with? So one thing.
Yeah, what happens now, Justin?
Well, so two things. One, the court goes out of its way. So after explaining why stare decisis does not protect Chevron and Chevron has to be overruled, the court immediately says, okay, so what does this say for all of the many cases that have been decided under the Chevron Doctrine in the last 40 years? And the court sends a very strong signal. Those holdings of those precedents, meaning how they read the statute or whether they allowed the agency to read the statute a certain way, might be a better way to put it. Those holdings are also subject to stare decisis protection themselves. So the fact that a precedent relied on Chevron deference to say it's okay for an agency to do this, yeah, if it relied on Chevron deference, then in some sense it's wrong. But being wrong is only table stakes to even get your foot in the door of having a conversation to overrule a precedent at all. You would still need to show it was egregiously wrong. It was wrong from day one. It's been unworkable. It's caused mutations in the law. Some shifting set of those, you need some critical mass of those other red flags, those other fatal flaws in order to overrule it. And the court says that's true of the Chevron case's substantive reading of the Clean Air Act itself. The bubbling approach to new source review, that's still good law. That's still a permissible reading of the Clean Air Act. It's only the meta doctrine that's gone. Going forward, courts can no longer defer to the agency, and we'll get into exactly what that does and might not mean soon. But the precedents themselves, in all but the most egregious examples, are going to be relied on. And there's a very strong signal being sent. And my guess is, based on the questioning and oral argument, that for you, Amy Barrett's in particular, that was her price of signing on in full to the opinion, because she asked repeatedly both sides in both cases about this in January of like, what do we do? What are the implications of all the precedents? Not just her, but she was the most concerned. And so the majority, written by Justice Gorsuch, is sending a very strong signal saying, let's not get nuts here, lower courts. Stare decisis is still a thing for all of these precedents. Few, if any, of those precedents are vulnerable on challenge now. We got to let the ball play it where it lay. But going forward, arguably for ongoing cases now, that's going to be fought out in a bunch of cases in a messy way. And certainly for any new challenges brought to any new regulations signed, issued, finalized by the agencies, there's no more deference. Okay, so what do we have? We're left now in a world which is really, we're no longer in the realm of Chevron, because Chevron deference, true deference in the sense of, I think my reading is better than yours, but your reading wins because it's a permissible resolution of ambiguity, that's gone. What are we left with? We're in the domain of a separate line of cases called Skidmore. Skidmore is how people refer to these. Skidmore actually way precedes Chevron, but once Chevron comes along, Skidmore then evolves in parallel with it to basically be, how do you treat an agency's reading of a statute, a statutory text ambiguity, if you're not giving them Chevron deference? You might not be giving them Chevron deference because it wasn't announced in the context of a notice and comment rulemaking. It was just a guidance put out or a letter from the General Counsel or whatever. That's the most common example in which you're into Skidmore land, but not Chevron land. But there are others. Okay. What does Skidmore mean? Skidmore is not, they call it deference. And at oral argument, the judges were saying, maybe we shouldn't call it deference because it's not really deference in the same sense. So what is it? It's going to sound fuzzy, and it is fuzzy. What Skidmore says is you should listen very carefully and respectfully to the views of the expert executive agency. You courts should keep in mind that this agency all day, every day, eat this statute for breakfast, lunch, and dinner, whereas you, judge, may have never heard of this statute, and you're never going to hear of it again. These are civil servants that are due to respect, and they're, subject to political control that's due to policy respect. And, they have to live with this statute, and they've been thinking about this statute a lot. And so they're not just any random schmo off the street. You got to really make sure that you're taking into account the relevance, to the extent there is relevance, of the agency's expert views. and you're giving it the full power that it has to persuade. What the heck does that mean? Justice Scalia, before he died, and Justice Kagan were both pretty open in their views of what this doctrine does and doesn't mean. The Skidmore doctrine does and doesn't mean. Scalia, near the end, would just say, like, oh, this is the deference that's not really deference. Kagan, I think, said something like, what even is that? In an argument, they get a little jokey with it. But, I mean, they're basically saying, what does this mean? Well, let's go back to the D&D analogy. If the now overruled Chevron deference was, if the statute's ambiguous, we both rule, and as long as the agency rules a 10 or better, they win. Even if, agency rules an 11, I roll a 15, the agency still wins because it clears that bar, that low bar, sometimes of rationality or permissibility. Well, that's not what Skidmore is. Skidmore instead is, you got to hit a 15. Maybe I'll give you a plus factor. Maybe you roll a 12, and I'll give you a +3, right? You have a Vorpal sort of persuasion or whatever, right? But this is going to be polarizing.
If you're the orc, you win, and
the audience that has played D&D is going to be, is going to be loving this. Maybe we're going to go, what are you talking about? But I mean, that's just the best analogy I've come up with. So, in other words, in the Skidmore world, the agency rules, and maybe it gets a little plus factor, although it's pretty loosey-goosey. A harsh judge isn't going to give it, the plus factor is somewhere between 0 and +3, basically, right? But if the other party, even with the plus factor, still does better, and if the judge thinks, hey, my reading or the defendant, the company's reading or the state's reading or whatever, that's better than the federal agency's reading, even once I lean in and make sure I'm being respectful and really taking seriously what they have to say, then the better reading wins. You have to ultimately persuade. That's the difference you're making now. The court still has to be persuaded that the agency's reading is the best reading of the statute, but there's this very sort of, let's respect, because they could have said, screw the government. The government's like any other party. They're like any party off the street. They're like the state of Nirvana. They're like the NRA. They're like the ACLU. They're like the Widget Corporation. They don't get any special respect. In his secret libertarian heart of hearts, Justice Gorsuch might have wanted to go there, but he wasn't going to get 5 other justices to sign on to that. So instead, what you end up with is, we're not poking the government in the eye. They're going to get a respectful hearing. You have to be mindful that their expertise may be relevant to the statutory interpretation question you have, but ultimately the buck stops with the judiciary. They cannot say you win because you're permissible agency. They have to bite the bullet and say the agency wins, if the agency does win, because it has the best reading of the statute. +1, +3, or +0. However, this is, now Skidmore can be played like an accordion, as it has been arguably already. So that's the world you're in. Now, let's be very clear about one thing. There's a whole separate line of case law that's evolved, which has to do with deference to the technical and expert judgments of the agency. Engineering calculations, economic predictions, factual descriptions of the world based on evidence in the rulemaking record. That is not affected, at least directly, by Chevron. That doesn't really have a name. I call it Baltimore Gas because there's a SCOTUS, I think, case from the 80s called Baltimore Gas, which, if I'm remembering correctly, it could be DC Circuit, but I think it's Supreme Court, says something like, when we're dealing with our debt, we give a high amount of deference to an agency when it's dealing with sort of expert, complicated technical questions of judgment within its wheelhouse. That is its own thing. And the majority says, look, we're not, yes, a lot of times the right reading of the statute is that Congress wants the agency to go find the best widget, and that's going to be hyper informed. The text is our job to interpret, of the text of the statute. The legal interpretation of what Congress said, that's our job. The views of the expert agency will likely be relevant, but we have to decide what the best reading is. But within the space of policy judgment that we decide the best reading of the statute is Congress has assigned the agency to go build a better mousetrap, then we're deferring to their technical judgments. That's a whole separate line of doctrine. Some people don't like that line of doctrine. They want to undermine it, but that's going to have to be a separate mission. Now, this
sounds like a better world, honestly, just to point this out real quick, because, I've seen 2 big criticisms of this is that the agencies are the experts, so we should defer to them, right? And we've talked about this. First of all, experts aren't immune to, overreach and abuse of power, so it's nice to have check.
Some might argue they're more susceptible to it.
Right, exactly. Exactly. And I won't go full conspiratorial here, but they've been responsible for a lot of evils in the world. And then 2, people tend to think that this is going to just, bring the Wild West back and that regulation is done for and whatever. But what you're kind of saying here is that there are other things in place where you give a lot of respect and a lot of, adherence to what the experts are doing and what they're saying, but they still have to have that check on them and that balance of judicial review.
I think it sounds like you can defer to the agency, but you're not obligated to defer to the agency.
Well, it's not defer. So what I would say is the best way to read going forward is we should stop calling it deference because it's very mushy because like think about in any kind of Zoom call on a team project, you'd say, Jane really knows this area better. I defer to her views. That could mean it's Jane's call, or that could mean I'm going to turn it over to Jane. Let's hear what you have to say. I'm going to really respectfully listen. But, if it sounds nuts, we might say, okay, yeah, that's nice, but we're not doing what you say.
Yeah.
Right. That like true deference, capital D deference in the now overruled Chevron sense. And it's clearer from the questions at oral argument than in the final opinion, but certainly in the final opinion, it's clear enough, I think. What the Supreme Court says is the fatal flaw of Chevron deference and why it is at least incompatible with the Administrative Procedure Act and to at least one justice, arguably potentially with the Constitution itself, is that true deference requires the court to give the win to the agency, even if the court has identified another reading of the statute that the court thinks is the better reading. Now, how many cases was that actually the real point of decision? Some, especially at the lower levels, but not all of them. Now we're left in Skidmore deference, but it's lowercase d deference, and I would really call it respect, which is that sort of, I defer to you because you wrote a PhD on this, so I want you to take the mic here, but I still then am the decision maker. I'm just making sure you really get to make your case in full, and I'm going to, if you have some rando who doesn't have the expertise, and if I have you, you're probably going to win. But you're not going to win because you're just a permissible reading of the statute. You're going to win because you've convinced me, maybe with a little plus factor, that your reading is the right one.
So the agency can win, it just doesn't necessarily win now.
And remember, even under Chevron, the agency didn't necessarily win. At step one, if the statute was unambiguous against the agency's position, the agency lost. At step two, and this did happen sometimes, if it was ambiguous, but the court decided that the agency's reading was not a permissible resolution of that ambiguity, it was too far out of bounds, then the agency lost too. So let's talk a little about what judges' behavior will be changed in what ways as a result of this.
We're getting very long on time, Justin.
Oh, sure. Okay.
And I want to respect your time because you're on vacation, sir.
So it's a working vacation. I could be brief. I could bang it out in 2 or 3 sentences. Famous last words, but I could do it to just try to give a sense to people of who's
Why don't you do that? And then I'd like to talk about what it means to
100%.
the current challenges to the Clean Power Plan 2.0, because ultimately that's, I think, where my interest lies in this. So bang it out in 2 or 3 sentences. Let's talk about CPP 2.0, and then we'll let you get back to living on the lake life.
Absolutely. So, for judges who have in good faith the whole time been trying to abide by the Chevron 2-step and truly defer to an agency if the agency's reading was better, those judges are liberated or burdened, depending on how you look at it, where now they have to decide what's the best reading. For those judges who may have been a little more cynically playing Chevron like an accordion and just deferring to the agency if they liked what the agency said, they're flushed out. They can't do that anymore. They can try to do some version of that under Skidmore, but those judges still have the burden. And I won't name any names in terms of which judges fall into which category, but you can probably identify them. Some judges at all 3 levels of court may start to rule a little differently, but this is arguably largely also a sign of the times of where this Supreme Court majority is in terms of, planting a flag. You mentioned the eviction moratorium case. We have CPP, Clean Power Plan 1.0. We have the OSHA vaccine mandate, but not the Center for Medicaid and Medicare Services vaccine mandate, which was upheld by the Supreme Court on the same day, I think, that the OSHA one was struck down. Different statutes, different factual scenarios. You have this trend of the Roberts Court more and more saying, stop being so aggressive and twisting your statutes from their position, and the agency's not getting the message. And this now is a very strong sending of the message. So in terms of litigation on currently ongoing litigation on recently finalized EPA actions, I don't want to, it's not appropriate to get into too much specifics of these individual cases, but if it's helpful, I can talk at a high level. What is this going to do in terms of how the agencies craft and then defend their regulations? I think that the overruling of Chevron deference is going to accelerate a pre-existing trend. It's important to note the Supreme Court itself had not given Chevron deference to an agency since 2016. The Solicitor General of the United States had not squarely presented a Chevron defense to the court in longer than that, since like mid-Obama, when Roberts made it clear that he was gunning for Chevron in various other cases. You know, they didn't want to give that target for the court to do what it just did here. So you're going to see an acceleration of a pre-existing trend in which the agencies more and more are going to pivot away from creative readings of the statutory language, and they're going to pivot more and more towards their docket and the evidence and their findings and the expert deference. The agencies do not want to be arguing now before these courts, and especially the Supreme Court, of what the words adequately demonstrated mean in the statute, or what the word cost means in the statute. They do want to be arguing about, look at my bajillion technical support documents in the docket, look at my agency expertise. You're supposed to defer on my economic calculations. You're supposed to defer on my engineering judgments. That is what they're going to say. Every statute is a permissible but broad grant of authority for us to go and build a better mousetrap or identify the better mousetrap, and then our technical expert judgment shows where that better mousetrap is. And so folks get, whether it's the oil and gas, whether it's the power plant, whether it's the FERC transmission, whether it's the SEC climate disclosure, all of that theoretically could play out. I say theoretically could because there's a meta issue of whether parties now who didn't know about the overruling of Chevron deference might need to rebrief things, go to the agency first. You know, that's going to play out in each individual litigation, how it plays out. But at least for new regulations, if there's a second Biden term or if there's another Trump term, then agency actions taken, the interpretations of ambiguous statutory language on which those agency actions are predicated, will not be deferred to by the court. That means, let's be clear about what that means. If you have a new incoming administration that reads a statute in a much more light touch, deregulatory, flexible way, like the Reagan EPA did, then let's be real. Your Biden appointed judges are not going to have to defer to that. Now, are there ways to play Chevron like an accordion where they weren't really deferring to it anyway? Sure, but they can't. They don't even have the fig leaf to hide behind them. They don't have any deference thing to do. You're right if you can persuade me, agency. That cuts both ways.
Interesting. So we'll wrap this up after this, but I do want to, and I'm not sure if you're up to date on this, Justin. So I'm sorry for putting you on the spot, but I know that West Virginia.
Sorry. Yeah. What's up? Sorry. Sorry for interrupting.
Oh, sure. I know West Virginia and 26 other states have filed a stay against the Clean Power Plan 2.0, and the agency had to respond to that stay. Where is that right now? And when can we expect further information on when, you know, I don't understand how all of this challenging a regulation works.
Okay.
So I know that they have to have some more of a substantive argument later on, but where are we in that process?
So, yeah, let's talk a little just about how it works, how the dance works generally, and then talk specifically about the power plant litigation. So generally speaking, when the agency issues the final regulation and typically or takes some other final agency action that you can challenge in court, then you have some period of time, depending on the statute that controls, plaintiffs who want to sue can go sue, and then Congress either told them what court to go to. If not, you just go to district court under the Administrative Procedure Act. Now, when I go in, I file, if I'm in district court, I have to file a complaint, which is a fairly lengthy document with a bunch of factual allegations. If I'm going into circuit court in the first instance, and under the Clean Air Act, all final actions are challenged in circuit court. It's just a question of which one. National rules go to the DC circuit. Locally applicable rules go to the regional circuit. My original petition is pretty bare bones. It's just like, here's the thing I'm challenging. You might want to say like, it's arbitrary and capricious, but you don't need to show a lot of your cards yet. And so in the typical course, you get a briefing calendar. You will file your opening brief as the party challenging, saying this is why this action is wrong, illegal, irrational, whatever. The other side gets to file their response brief. And then typically the party that's trying to change the status quo gets the last word. So the challengers filed their brief saying, here's why you should strike down this regulation, court. The government defendant and any parties like blue states or whoever that have intervened to defend this administration all get to write their brief saying, no, it's fine. And then you go back to the plaintiffs or the petitioners for their last word as to, no, here's why we're right. Their reply in support of their original motion or brief or what have you. And then the court will deliberate. They'll schedule an oral argument. They'll hear you out, which in circuit court is a very scripted sort of way. You get your argument, the defendant gets their argument, and then you get the last word, a rebuttal. And then they huddle. They go off into their secret world of judges, and then sometime between a few days and a few years in egregious cases later, they come out with their opinion deciding the case. That's called merits litigation, which is just who wins, who loses.
Yep.
But there's something called a stay or a preliminary injunction. And this is not limited just to agency actions. This can be available in other litigation contexts. And the idea of a stay is it is a temporary pause. In this case, it's blocking the regulation from going into effect, whether for some parties, the parties before you, or in some cases nationwide for everybody. The Supreme Court just put a stay on the Clean Air Act good neighbor rule as one of these end-of-term major administrative law cases. So that's what they did. So the stay halts the effectiveness of the action, the administrative regulation or the other action in question, whether for some parties or nationwide against all parties. In order to grant, the stay is not a final merits resolution of the case. The court can change its mind, and when it comes to it can dissolve or lift the stay or the preliminary injunction. Those are basically synonymous terms. Later on, or you can go up to a higher level of court in some instances and say, hey, this injunction was wrongly issued, and the appellate court or SCOTUS could say, no, yeah, you're wrong, I'm lifting that stay. You can go forward, agency rule. In order to get a stay, you have to show 4 factors. You always have to show you are likely to succeed in the ultimate merits litigation at the end of the day. You, the party asking for the stay, you are being irreparably injured during the course of litigation, meaning you're being harmed in some legally recognizable way that can't be made good after the fact. You can't just cut a check later to make you good. So examples of that would be harm to sovereign injury of a state that says, hey, I'm the sovereign regulator, I'm supposed to make the calls here. That is considered, at least in most case law, irreparable harm. I'm having a lot of financial burden of having to comply with this regulation, and because the cause of that financial burden is the government, there's no waiver of sovereign immunity. You know, if the government hits you with a car, you can file a tort claim against them. But if you're burdened by a regulation, too bad, so sad, you can't get a check from the government afterwards to pay back your compliance costs. So at least in some courts, in some instances, say, yeah, that's irreparable harm, whatever it is. So likelihood of success on at least some aspect of the challenge, irreparable harm during the litigation, the balance of the equities, meaning basically like if we issue the injunction and we're wrong and that gores one party's ox versus if we don't issue the injunction, the other party's ox, who gets hurt more, whose interests are harmed more by the granting or withholding of the stay. And then the 4th factor is where is the public interest? And when the government's a party, they're presumed to speak for the public interest. So in challenges to agency regulations, so likelihood of success, irreparable harm while the litigation is going on that can't be made good after the fact once they reach a final merits resolution, and then the equitable analysis of whose ox is gored more and sort of what values are at stake there. So what happened with 2 major EPA regulations, both issued under Section 111 of the Clean Air Act, which was the same authority used for the Clean Power Plan, the so-called Clean Power Plan 2.0, which is a successor regulation to the Clean Power Plan, which regulates greenhouse gas emissions. It modifies the already existing regulations for new gas-fired power plants, and it creates, there currently are no, but it has just created regulations on greenhouse gas emissions from existing coal-fired power plants. And you have another regulation addressing greenhouse gas emissions from new and existing oil and gas wells and other oil and gas facilities. These are separate rules. They're taken under the same statutory authority. Some of the issues are similar, particularly including state authority on regulating existing sources. The history is really messy. They were taken, these rules were finalized at different times, but they're now almost neck and neck. The stay motion was just denied by a DC Circuit panel like 2 days ago, I think, in the oil and gas methane case. My understanding is that the power plant stay motion should be fully briefed up. I apologize, I haven't checked the docket in a little while, but to my understanding, they have not ruled on it yet. It may likely be, it should be the same panel. If they decided this month anyway, it will likely be the same three judge panel, the motions panel that just decided the methane stay. And then if the DC Circuit denies the stay in the power plant rule, then the parties who still want to stay, their options are ask that same 3-judge panel to reconsider. That's Probably sometimes you do it, but it's very rare. Normally you do that if it's a really weird opinion with like, 2-3 separate writings and a lot of factual arguments between the judges or whatever. Or you could ask the whole DC Circuit to reconsider. That's called en banc, which is law French for the whole court acting together, not a 3-judge panel, but all the active status judges on the DC Circuit. Or you can go straight to the Supreme Court. And you don't have to do those other options first. In regular cases, you like to. For the huge Super Bowl, big ticket cases, more and more now parties are just going to the Supreme Court to try to get their stay.
Yeah.
But crucially, whether a stay is issued or not, you still then go through that longer merits briefing. You schedule the argument on the merits, whether there's a stay or not issued. This is happening on the Good Neighbor Rule right now. They're in merits briefing on the Good Neighbor Rule right now. That case probably won't even be argued, let alone decided, until 2025. But currently, at least for the parties that brought the case, that rule has stayed and can't be enforced against them. And those states and parties. You could see that here. And so you should see a ruling on the power plant stay motion soon. If it's granted, power plant rule has stayed until the merits litigation is over. Stay could be lifted by the DC Circuit or eventually the Supreme Court. But if the DC Circuit grants the stay, the rule is not in effect until the litigation's over. If they deny the stay, you either get the DC Circuit itself as a whole to grant the stay, or you get Supreme Court to grant the stay. And I'll just note that in February 2016, the Supreme Court stayed the original Clean Power Plan after the DC Circuit denied the stay. That was the first time in history that the Supreme Court stayed a rule when the litigation was still going on in the lower court. And that kind of broke the seal, and they've been doing it a lot more since then. And it gets kind of controversial. Justice Barrett, in particular, she wrote the dissent in Good Neighbor, and she's signaling, let's not get nuts with this extraordinary docket of stay motions. But at least some of the justices are doing this more and more often. So I'm not in the predictions game here, but I'm just saying over the next weeks and months, you're going to probably see, if the stay is granted, then maybe the government or NGO parties or blue state parties will try to get the Supreme Court to lift the stay or get the whole DC Circuit to lift the stay. And if the stay is denied, then you're going to likely see some attempts to take that upstairs too. Meanwhile, that merits briefing will be going on, and unless it's halted as a result of a change in presidential administration, which is not a guarantee, I'm just saying that's an option that can happen, then it's going to keep going on the merits litigation, which won't be resolved by the DC Circuit until a year from now, probably, if not more.
All right. Well, I think that's a good place to end it. So Justin, thank you so much for being on the show. I learned a lot, and I hope I'm sure our audience will too. So where can people find more about your work or hire you to be their lawyer?
I am CGCN Law at CGCNLaw.com. If you Google my name in CGCN Law, you'll find my number all over the place. I've talked a lot about the power plant regulations and other EPA actions, mostly for the Federalist Society. So if you Google Justin Schwab Federalist Society, you'll see a link to all of that. And always happy to discuss these issues. Thank you very much for having me on, and good luck with the podcast.
Hey, thanks very much. And thank you for tuning in. Make sure you subscribe to the Energy Bad Boys Substack for more podcasts like this. So thanks and have a great day.